It is Tuesday, September the 15th, 2020, and it's about 8:35 p.m. And this is week 6. This is it. We're not going any further. There's no week 7. It's um, Week 7 is in the 11-week courses, so you don't have that. And the course will absolutely end in 3 days, as I will be sharing with you. So let's not belabor the point. Let's take a look at that. Okay, I know that. Justin, where are you? What state are you in? Type in the chat box. Where are you? Oh, Dixon, Illinois. Oh, wow. Oh, uh, that was the I think it was the home of the great debate. Yeah, I know Dixon. Yeah, I went to a retreat when I was yeah, Reagan. Yep. Yeah, the Dixon, Illinois. Wow. A lot of people don't know about that place because it's kind of hidden a little bit, but yeah, right near 88. But yeah, Dixon, Illinois. I'm thinking there was another debate that took place too in Dixon, Illinois. And I might be wrong, but Dixon isn't that's where Reagan is from, isn't he? Isn't he? Yeah. Yeah. So everything is called Reagan Road. Matter of fact, isn't that stretch of the uh, Swift? Oh, wow, he graduated from Dixon High. That's funny. Guess what? I went to Dixon Elementary School in Chicago. So I don't know if it's the same Dixon. It was Arthur Dixon. That was the name of the school that I went to in Chicago. I don't know what the first name of the Dixon is, but Dixon, Illinois. Oh, John Dixon. Oh, okay. JD. All right. That is really something. Yeah, I went to a retreat there. Gosh, I think I was probably 16 years old. That was a long time ago. So I don't remember where we went because it's erased from my memory. I have a photographic memory, but I just remember a young lady that I met that was from Freeport. You know where Freeport is, right? Yep. And that's where she was from. Her name was Kitrin Lee Lapkin. We became really good friends uh, while I was still in high school. So, but that's cool. Well, let's get out of the line. We're going on. Amanda's down in Texas, and we're way up here. So let's get right to it here. As you can see, this is it. The last lecture. I will be. Oh, he's headed to St. Louis. Tell him to make sure he wear mask, gloves, and if he can wear a hazmat outfit because COVID is rampant. Yeah, it is really rampant there. My wife's niece had it, and and then another grandniece went to visit her, and they put her shelter in place. Houston is no cakewalk either. Yeah, my nephew works for the airline there, Southwest down there. So yeah, he's talking about that as well. So not to mention the storms that come through there. So anyway, we're week 6 will be recorded here. And now let's take a quick look at the course calendar. And here we are. You see the little um, darkened in screen. Why I don't see anything. I don't know why. Why am I not seeing the calendar? for 150, probably because there's no check mark there. And that is why. There we go. So there it is. So now this is where we are. Initial post due tonight. Murder or self-defense. I've looked at some of those. And then, of course, your reading assignment was yesterday. And then, of course, your live lecture, the final one. And 18th, just 3 days away, is it. That is the final day of class. All assignments from weeks 4 through 6 need to be in. I'm not accepting 1 to 3 anymore unless there was extenuating circumstances that happened. And I think I only had one student that had that. And she's, so yeah. So the 18th is it. So your reply post is due rather than Saturday, it's due Friday the 18th. Your final written assignment. You know what that is? It's your quiz. Remember what I told you about that one? And that particular quiz might as well be called a final exam because it covers, anybody remember what weeks that it covers? Yep. Yep. 4 to 6, 4, 5, 6. Absolutely. And so the best way to prepare for this is do those practice exams that we go through every week at the end, and also utilize the PowerPoints. She's always trying to get some bonus points. That's funny. I you know, I can't blame a student for trying. So, okay. So that's the calendar. That's the last time you'll see it from here. So now let's go take a look at what the announcement is for the week. Yeah, excellent attitude. That's right. I always tell students, I says, maintain a positive attitude and you'll end up with a positive result. I wonder why I don't see any announcements, because there are some. Oh, duh. How'd that happen? Oh, I thought that I was in 150. I was. It kicked me out when I fixed that calendar. Let's go back and pick up. There we go. Okay. But the calendar I showed you, I think said 150. But at any rate, you know that I don't, this is some wacky stuff going on here with this this thing. I know that for about 5 days we're not going to have access to Blackboard, but that's during the time when everybody's on break. So let's look at our announcement for today. Here we go. All right. So this week we're going to deal with defenses to criminal liability. Chapter 10 of a brief introduction to criminal law. I sent you the PowerPoints. No one told me that last week that I didn't send the PowerPoint. So, um, how to get away with murder? Yeah, that is what this week is all about. Yeah, or as we lawyers call it, uh, technical self-defense. Yeah, there was a PowerPoint. There's a PowerPoint every week. But so anyway, I did send it. I sent it to you guys, so you guys have both week 5 and week 6, because you're going to need week 5 to get ready for the test. Mental disorder. We're going to talk about the insanity defense and involuntary intoxication, mistake of fact, mistake of law, self-defense, and then we're going to wrap up by going over some of these quiz questions to get you ready. So your discussion assignment, as I said already, murder or self-defense, initial post due tonight, reply post due Friday by 11:59 p.m. And then the quiz, which, as I said, don't even think of it as that. Think of it as your midterm, as your final exam, rather. You had your midterm week 3. It's the same format, same number of questions. Only difference is that the questions will come from weeks 4, 5, and 6, as you guys have both so accurately shared. And that is due by Friday, 11:59 p.m. Now, if you finish the exam and it is Saturday, it's going to get kicked out because it's not going to allow me to grade it because the system grades it. And if it says 12:01 or 12 a.m. the 19th, it's going to be a 0. So you want to make sure that you don't wait that late to do that. And then I'm reminding you again, once again, that the term ends, and then take time to complete the end of quarter survey evaluation. And you know about my motto, adversity is the springboard to success. You know what that is all about from me discussing that with you earlier on in the course about my experiences in personal life. And if you were in this course and also drugs and crime, um, uh, Justin, are you in drugs and crime also, or you just in this course? Yeah. You had drugs and crime before with me? Okay. Drugs and crime is a course that you really want to take. It's offered term 2, and I'll be teaching it again. Excuse me. It's a very, very interesting mind. Um, how should I say? It puts you in the idea there's some additional things that you do other than lock people up for crimes. All right. So let's go right into the module. Again, this is real quick because we already know what the assignments are. The discussion, murder or self-defense, and you're going to elaborate on that. And then there's, of course, the quiz that you're aware of, and then the live classroom. So let's get into the meat of what we are going to talk about. Oops, I don't want to show the course materials because you already know about those anyway. Here we go. So we're going to deal with self-defense, mental disorder, insanity defense, involuntary intoxication, mistake of fact, mistake of law. And we're going to conclude with my favorite area, self-defense. Then we're going to deal with these key terms for practice and so forth. And then we're going to call it a day and a quarter. So mental disorders, insanity defense. You should be aware of right up front that the insanity defense is one of the hardest defenses to establish. I have had cases where there are things that people do are very bizarre, very bizarre. But when they were subjected to um, the examination uh, by the psychiatrist says, "Yeah, that was bizarre what they did," but either they knew what they were doing or they did something to indicate that they were trying to cover up something, which means they knew they had done something wrong, or either they plotted and planned one or the other and did something really bizarre. In that case, the insanity defense is out the window. I have, in all my years of representing people from 1978 to 2000, and the many trials that I had that I was very successful with, I was not successful with getting an insanity defense. And I'll tell you why a little bit when we talk about it. Well, first of all, you should be aware of the fact that the insanity defense is what we call an affirmative defense, which means that you have to admit or basically say, yes, the person did it, as opposed to saying that you got the wrong person. No, you got the right person. But because of some defenses that we call justification defenses or excuse defenses, um, the excuse defense fits perfectly into the insanity defense, where because of the law, that person is excused from being found guilty. So the insanity defense is basically dealing with the mind, or as we like to refer to as it's quoted here, mental capacity to commit a crime. And so again, the key thing is that you cannot turn around and say I didn't do it and claim the insanity defense. You have to say, yes, I did it, but that at the time that I was out of my mind. Literally, that's kind of the term that we're looking for. And it's one of the most widely recognized defenses that is not able to be used. And so did I work with anyone in the, let me see. Let me see what he asked me. No, 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 I did not. But I know about it though. Yeah. But I dealt with many of those types of situations. So, yeah. I've got to do something. I gotta pause this a minute. I gotta pause this recording. Gotta pause it. Okay. Sorry about that. And so, as I was saying about the mental disorder and the insanity defense, yeah, it's a highly recognized defense, yet it is not able to be used successfully. Uh, so, uh, so, so when a person is found not guilty by reason of insanity, it doesn't mean that that person though is free to go. In other words, they don't walk out of the courtroom. They find themselves in the situation where they end up being put into a mental hospital, and they're treated, and they're not released until they are able to find themselves capable of functioning and has to prove that they're competent before going back in the community. Now, in most states, um, except Idaho, Kansas, Montana, and Utah, they do, these four states do allow guilty but mentally ill verdicts. And those states, if the defendant is determined not to be guilty by reason of mental defect, then they're committed immediately to a hospital. But I want to tell you that, again, it's very, very difficult. Um, Justin made me think about the home of Ronald Reagan. As you may or may not know, that there was a young man who was deemed to be mentally insane and was committed to a hospital for many, many years. But I think either last year or year before, he was finally released. His name was John Hinckley. And John Hinckley attempted to assassinate the President of the United States, and a Secret Service agent who is now just retired as Chief of Police of Orland Park, a community, yep, a community right here in our Chicagoland area, ended up um, uh, going to jail for it. And but the police officer, the Secret Service agent, took a bullet along with the secretary. I think he was the press secretary, Brady. Thus came the Brady bill that has to do with background checks because of that. But anyway, John Hinckley was committed, so into an institution and stayed in that institution for many, many, many years. So I'm going to talk about one though that happened here in Illinois, other than and her name is Amanda Wallace, and I'll talk to you about that in a minute. It wasn't my case, but I know a whole lot about it. But there are three theories of the insanity defense that you need to be aware of that are used throughout the country. One is only used in one state, and that when we get to Durham, we'll talk about that. But let's talk about the Norton rule, or the rule that determines whether a person was right or wrong, whether they knew right from wrong at the time they committed the offense. So the theory is based on these two bullet points that at the time of the murder, and the defendant thought they were stabbing someone with a knife, but with a straw, or at the time the murder took place, that the defendant knew that they were stabbing someone with a knife, but for a reason, as a result of a mental condition, they thought it was right to do what they did, and that's it. So an example is, if you look at the Florida statute, it can be established if at the time of the crime, remember at the time of the crime, the defendant had a mental infirmity defect, and because of the condition, the defendant didn't know what they were doing or its consequences. That's the right wrong part. Or although they knew what they were doing, its consequences, they didn't know whether it was wrong, right, or wrong. So you have the right or wrong test, as it's referred to oftentimes, and so consequently, as a result of that, you find an individual who will be released simply on they're not aware of what they were doing at the time, the offense, especially the one that they talk about where you thought that you were using a straw, but it was really a knife, because the mental capacity that you lacked at that time couldn't tell you the difference between a straw. And there are some extensive testing that psychiatrists do, and the psychiatrists are able to determine whether or not the person is faking. So the Norton, known as the right or wrong, and you want to remember this because it's going to come up on the test. The Durham rule, only in one state, and that's New Hampshire, is also known as the product of mental illness tests. So based upon Durham versus U.S. 1954, criticized the Norton rule, saying it was too simple. In other words, mental illness was more than right or wrong, that some actions could be the product of a diseased mind or mental illness. So the Durham test is more liberal than Norton, and stretches the intellectual question to this: did the defendant know the difference between right or wrong that is expressed in Norton? And it's based upon the mental illness. Now, it sounds almost the same, but no, because it's easier to prove and satisfy the Durham rule than it is the Norton test. Okay, in other words, it stretches the Norton test to a level that if we had it in my state, we would have more insanity defenses being successful. But then the third one came about, where they tried to codify it and bring it to all of the states of the United States. And every state in the Union, except one didn't deal with that from that perspective, and that is, anybody know what state? Okay, they have a different legal system. No, they have a different legal system than all the other 49 states. Louisiana. Louisiana is based upon the Napoleonic Code. And so with the substantial capacity test, it removed the recognition of Norton, that he didn't know the difference between right and wrong, but rather as a result of a mental disease or defect lacked substantial capacity. They didn't have substantial capacity to appreciate what they were doing was wrong. Wisconsin has a good example of that. A person is not responsible for criminal conduct if at the time of the conduct, as a result of mental disease or defect, the person lacks substantial capacity either to appreciate the wrongfulness of their conduct or the requirements of the law. Now, as liberal, or as that's broken down in Wisconsin, um, Jeffrey Dahmer, you guys familiar with that name, Jeffrey Dahmer? Yeah, he was the one that ate human flesh. He was a cannibal, and but in Wisconsin is where he committed his offense. And had it been in Illinois, he would have been executed under the death penalty because he plotted and planned and did all kinds of things. So, like I said, it was very bizarre, but that it wasn't bizarre enough to satisfy. Um, yeah, he was murdered, but it wasn't in Stateville. He was murdered in Wisconsin. He was actually murdered in prison in Wisconsin. And the bottom line is that um, the deputies turned their backs, and he was killed. He was killed in a gang attack. So anyway, uh, the key thing for you to remember in each of these tests is, number one, that Durham rule only applies in New Hampshire. The right wrong test is going to be the one that is Norton. And then the term substantial capacity is going to tip you off. That is the substantial capacity test. Those are the three tests. Um, Now, you should be aware that the presumption is that people are sane, which I kind of chuckle about sometimes when I hear that said. Um, it is the defendant's burden, though, to provide evidence that they were not sane at the time of the offense. And that's what the defense attorney will do. We'll file a motion to have the individual examined. Now, unfortunately, most of my clients didn't have the money to hire their own psychiatrist to do it, and they had what we call Dr. Reifman, who was the Cook County examiner, I mean, the psychiatrist, and his office was responsible for determining whether or not a person committed the offense or was insane, and it wasn't really very, very successful. So, but anyway, the burden of proof um, to determine whether a person is insane is not reasonable doubt, but preponderance of the evidence or clear and convincing evidence. Is like in a civil trial. So again, keep in mind what I said. When a defendant wishes to pursue a not guilty by reason of insanity, where the hearing is determined to whether or not that person was sane at the time, and the psychiatrists do their thing, the judge or the jury will then render a decision whether or not the person was insane. And of course, you know what happens. Again, they are put into a mental health facility. Now, let me tell you about the case of Amanda Wallace. Amanda Wallace. Amanda Wallace is a woman who the DCFS, they kind of messed up again with, there's a young man I think it's AJ Friend is his name. The kid where the parents killed their own child has been recently in the news here in Illinois. And so I say that not because of insanity. I say that because of the fact that the individual was the DCFS was involved with that. So in this case with Amanda Wallace, DCFS had taken her child away. And shortly after that, for whatever reasons, they gave her back the child. Within a short period of time after that, and you can Google Amanda Wallace, AmandaWallace, and Amanda Wallace hung this child. There was a baby, and the kid died. Now, Amanda Wallace was determined to be insane, and that if you saw her, I saw her when I went to visit one of my other female uh, individuals while they were waiting trial, and she was sitting in a corner, and she was rocking from side to side, and if you saw her, she was out of it. She was totally out of it. And so she was found not guilty by reason of insanity under Illinois. She's one of the few cases I'm aware of. But it was such an egregious situation there that took place. And it was really sad. And she was definitely not faking it if you'd have seen her. So she ended up, of course, finding herself in a situation where she didn't live long either. But that's pretty much how we deal with uh, what was that you're saying? Let me go back to the where is it? Yeah, these cases though, they take a long time uh, to uh, to go to trial. That's for sure. That's one of the things you should be aware of. Okay. All right. I don't know why I don't see. All right, let's go back. Okay, so now you see it there. Okay, so anyway, I don't know what happened to my when I paused it there. Okay, let's go back to why the recording is not moving. It should be moving. Give me a minute here. Let me see what's happening here. I don't know what the devil is going on here. Can you guys see everything that I'm looking at on the screen? You can? Okay. For some reason or other, it's not showing. Okay. Okay, let's go back to week 6. Okay. Okay, so let's deal with involuntary intoxication. Be aware, first of all, number one, you will not be successful with establishing involuntary intoxication um, because of the fact that you take a drink on your own. It is, as I was saying earlier, it's an affirmative defense where you admit that you did it, but that because of the intoxication, that you should be excused from committing the offense. And by a preponderance of the evidence, you have to establish that at the time of the offense, that you were intoxicated or impaired involuntarily. Involuntarily. And the way that involuntary intoxication occurs is if your drink is spiked or something that you're not aware of takes place, such as having a Mickey or something put into your drink, and then you operate out of control. That's the only way that it's going to happen. If you look at the statutes, it says it is an affirmative defense in Michigan to a specific intent crime for which the defendant has the burden by preponderance of the evidence that they voluntarily consumed illegally or obtained medication and didn't know or should have known they would become intoxicated. Okay, so um, similarly, you find yourself there, you know, in that situation. Okay. All right. And then, so that's it for involuntary intoxication. You cannot get away with it by saying, I had more than I thought. No, it's not going to be successful. Mistake of fact is very simply when someone commits a crime, but they didn't understand the facts or the elements of the crime. That is, a person is not relieved of criminal liability because they engage in conduct under mistaken belief. In other words, ignorance of the law is not a fact. But under mistake of fact, the individual can be claimed if the action is related to element of the law in question. Let's show you with this scenario at the bottom to make it very clear. It says Lisa is making a large purchase of home goods at a store, and that she puts the more at the bottom of the cart, as you find yourself in situations where you've done that before, and the cart is filled, and she doesn't end up paying for it because she's distracted and the clerk didn't ring it. So when she gets ready to leave out, the loss prevention officer could inform her that she didn't pay for the lawnmower, and then she could say, oh, I'm sorry, I didn't know that. The loss prevention officer, if they called the police and requested that she be charged with theft, she'd claim a mistake of fact because she wasn't really trying to. The key thing is that the intent had not been established to take the item without paying for it. Okay. Mistake of law. Mistake of law is different. Mistake of law can take place when an individual relies upon a law that was later determined to be unconstitutional, or the person acted in good faith with what the court said that they should do, or a person relied upon the advice given by a person responsible for administering the law, such as a police officer, and then they got stopped by another police officer, or a person committed an act contrary to a law that hadn't been published. Let's take the example down here at the bottom here. Paul had a suspended driver's license and wanted to drive his ATV to work. So his mother called the local sheriff, and the sheriff said it's okay, even though the license was suspended. And so one day he was stopped on his ATV and was cited for operating with a suspended license. Well, he was convicted while driving on a suspended license. However, Paul appealed his conviction, and it was overturned because he relied upon what the police officer told him. And so that's the way that mistake of law can take place. Okay. Paul only drove with a suspended license because he was given advice by someone who should know the law and apply it properly. All right. The last topic I want to cover is self-defense. Now, self-defense is all across the United States, which allows you to use force to protect yourself or another individual. And it can be proved that the fact that individuals find themselves from being placed in a situation with self-defense when they do something to protect an individual. The amount of force, though, used has to be appropriate. So let's say, for example, someone raises their hands to hit you and then you take out a gun and shoot them. That's not self-defense. But if they have a dangerous weapon and come at you, then you can. Let's consider the following scenario. Bob walking on a sidewalk with his girlfriend, Margaret. Bob and Margaret are approached by a drunk man who threatens to punch Bob in the face. Bob attempts to avoid the conflict and tells the man, just keep walking. The man then shoves Bob and draws his fist back to hit him. Bob reacts quicker and he punches the man in the face and he falls on the ground. So far at that point, it's okay. But Bob, because he was upset that the man tried to assault him, jumps on top of the man and beats him until he becomes unconscious. So he went beyond self-defense and crossed over the line, and self-defense would not be adequate. So it's quite clear that the jumping on the man was, until he was unconscious, did go too far. In my state, Illinois, and we use this many a times, a person is justified in use of force against another when and to the extent that they reasonably believe that such conduct is necessary to defend themselves, that's what I was saying, or another against imminent use of unlawful force. He is or she is justified in using deadly force or great bodily harm only if the reasonable person believes that such force is necessary to prevent imminent death or great bodily harm to himself or another in the commission of a forcible felony. So, dealing with Bob's situation, it's quite clear that the initial use of force to stop the unlawful force was justified. But the great bodily harm when he beat the man unconscious is important to know that he went beyond the protection of self-defense. Okay. And then many states deal with the issue of self-defense from the perspective that you don't have to retreat. But there is the stand your ground concept that takes place across the country. Anybody know what state is noted by almost everybody dealing with stand your ground? Do you know what state that is? Nope. Texas is not the one that made it known. It's another state. It's where the Trayvon Martin case took place. Anybody know what state that was? Nope. It's a peninsula. I just told you. Yep, it's Florida. And in Florida, that's where the stand your ground became, like all over the country, we started to talk about, where it doesn't require a person to retreat, presuming they're engaged in uh, uh, a legal activity and that they have a right to be where they are. But however, though, remember, the individual cannot assert a stand your ground claim if they're committing a crime while attacked. And also, you can't claim self-defense in cases where you provoke the attack. So, though some states will permit a self-defense claim where the person attacked could have avoided the use of force, which is commonly re referred to as a duty to retreat. So you have to decide in your jurisdiction whether there's a stand your ground or duty to retreat state. And many states have the duty to retreat. They want you to try to retreat if possible, which I think is bad because of the fact that it puts a person in a position where they got to make a decision about trying to get away, and it could be too late at that time. The final points are the battered women syndrome. This is where, and it could be now the battered person syndrome, but originally it was known as battered women syndrome because it was primarily males on females, where because of domestic violence that took place constantly on an individual, that individual, if they um, were to kill that person, then they could claim that because of the many beatings that they suffered, that they thought that the next one was coming. Here's a scenario here. The battered women syndrome claims in some instances where domestic abuse believe they are in a constant state of imminent danger. So let's say Diane has been physically abused many times by her husband, Jim, over the 10-year period. Of time Jim's drunk, and that's when she's battered the worst. And she's even been knocked and choked unconscious before. One night, Jim comes home drunk, and they begin to argue over his drinking problem, and Jim begins to escalate on Diane. Fearful that she will be battered again, she shot Jim. Diane is likely to argue self-defense. Now, you got to remember, in order to do that, you got to do it contemporaneously with the time of the threat. I know of a case of a young lady here in Illinois who found herself married to a guy, and he was violent like Jim, constantly beat her. And she got tired of the beatings that she suffered. And so what she ended up doing was she decided that enough was enough. And so she found herself in the situation where she wouldn't take it anymore. And so because of that, then she found herself um, shooting him while he was asleep. Well, she was found guilty of murder because she was able to get away, but she did not. And so the battered women syndrome would only work if it's consistent with the time that an imminent beating is taking place. The castle doctrine, very simply stated, is that a person has a right to protect their dwelling. That's a place where you're supposed to be able to relax, and so there's a presumption that if a person kills someone who tries to force himself into their homes, then they can use the castle doctrine as a basis for an affirmative defense, and they can use that to stop the intrusion. That's it. That is it. And so the final thing that we're going to talk about is police officers. We have a whole lot of that going on right now, the use of excessive force to determine whether or not if a police officer goes beyond their ability or necessity to use deadly force. And so, that is a big problem nationwide, as demonstrated by, for example, the Breonna Taylor case. I don't know if you heard about it today. They decided to award the family $12 million for the loss. I mean, that's not going to compensate for the loss of that individual, but what the state jurisdiction is doing is admitting that something wasn't done right. Of course not. Everybody knew that before that. But anyway, the point of the matter is that now they're calling for some other changes. And my whole thing in a nutshell about these excessive force cases, um, the case that happened, of course, which is George Floyd and several others, but George Floyd is one of the most egregious ones that anyone ever saw. And the point of the matter is that there needs to be more training for law enforcement officers so that they can do things, doing away with the so-called chokehold and things like that, which they tried to start to do away with when Freddie Gray was killed. But there's a number of instances where, not bashing police officers, but that um, there needs to be, as I say, well, somebody just said the same thing in the case of Sabrina Taylor, psychological testing, and so it's problematic. There are some people who have no business being police officers because of how they haven't dealt with their personal issues. So yeah, people do become cops for the wrong reasons, a lot of them. Now, one of the things that I will tell you is that whether you know it or not, one of the big areas of domestic violence is committed by law enforcement officers on their spouses. Did you know that? And so that goes with the psychological issues that are involved. But the key thing to remember about use of force by a police officer, they have to use that which is commensurate with the thing that is coming at you. Let's say, for example, like here in Chicago, we had the Laquan McDonald case where the police officer fired 16 shots. 16 shots. And that was excessive. That was totally excessive. And what happened in a rare occasion in Illinois, Jason Van Dyke was indicted and charged with murder, and he was found guilty of murder in the second degree, and he's serving time right now for that. But the point of the matter is that it is important for people to understand just because you carry a badge and a gun does not give you a carte blanche on using deadly force. That's the key thing, okay? And needs to be looked at very, very carefully. Anytime a police officer uses force, there's a review to ensure that the force is proper. Of course, deadly force is the most highly scrutinized because the death of another person is a final thing. So anyway, the point of the matter is, I know when I was a police officer, we had extensive training about it, and I pulled my gun several times, but I never fired it at anyone. Never had to. They train us to try to talk to people, and we use our voice more than we use that gun. And you can use it, but you don't want to fire it. And the other reason you don't want to fire it, because the paperwork that you have to do uh, after doing that is very, very, very extensive. So, well, that's it for the self-defense aspects of it. So now let's look at some of these key terms as we wrap up. Okay, let's run Adobe Flash. And so these are the things that you need to make sure that you're aware of. A legal concept that permits people who are occupied within their dwelling to use force to stop the intrusion. The presumptions that the deadly force was used to prevent great bodily harm. What do we call that? Yep, there we go. And then you go to the next one. A test only used in New Hampshire that is applied to determine if a person was sane at the time they committed the crime. What is that? What is it? What's it called? What was the name of it? Durham. Remember, after US versus Durham. And so you take each of these and you go through, and you want to make sure, by the way, at least some of these I know are on the test. Hint, hint. I've said that before, and you've heard me say it before. Then let's go further down. Okay. Uh, Practice of mistake or fact. So you can deal with mistake or fact examples. And do study these. Okay. Jane has a white cat named Snowball that wears a pink collar and is let outside each day. One day the cat doesn't return. A few days later, while out looking for her cat, she finds Snowball and brings her home. However, later that day, she realizes that the pink collar has a tag that says Princess on it. Jane contacts the police, but fears that she will be arrested. Mistake of what? Yeah, because she thought that was her cat. All right, that's correct. Now, if she did discover that it wasn't, and then decide to keep it after that, then she would have a problem. Eric waves down a police officer and asks, "My landlord locked me out of my apartment. Can I break in to get my stuff?" And the officer responds, "Go ahead." First of all, number one, that would be, if an officer told you that, don't listen to it. It's not. Yeah, you're going to get in trouble there. It's a mistake of law. Yeah. So those are some examples. The final thing is the practice quiz. Some of these questions, as those of you who took the test recall from week 3, they were taken from here. They scrambled some of the stuff around. Now, I want you to tell me which one of these applies here. Read it over. That's right. Right, wrong. Read this one. What affirmative defense? And actually, yeah, it is intoxication, because he was involuntarily intoxicated. That's the key. Remember, just being intoxicated is not good enough. One more. What standard of proof has to be met to prove an intoxication defense? Yeah, if anybody says probable cause, I'm gonna say, what? Reasonable suspicion or mere preponderance. So it's between these two. So which one is it? That's like a civil suit. Yep. And those are some of the things that you can do to get ready for this test. Any questions? Okay. No questions here. All right. Well, I hope that you have uh, enjoyed this class. Hope you learned a little bit about how to be not a defense attorney, but at least to understand how criminal law operates. Trust me, it's a whole lot more to it than this. And so I want to give you um, a key phrase. I wish you guys the best um, and find yourselves. Hope I see you in other classes and that stay safe, enjoy your break, study hard, and get ready to do well on the test.
Actually, I do have a question.
Go
I do
ahead.
have a, but it's about the break because I can't seem to find anything on it. How long is that break?
How long is what?
The break.
Oh, we don't start classes until the 5th of October. There you go.
Awesome. Thank you.
Okay. All right. Anything else?
Okay, Justin knew that. Guess I should have.
Yeah, it's there. So, as I was telling you guys earlier, I just found out what I'm gonna be teaching term one, and probably, did either of you have introduction to corrections yet?
No. Well, I haven't.
Okay.
I think
Okay.
Justin was in my class last term with
Okay.
Professor Riley. I
Did
think
you?
we're kind of on the same track here.
Okay. And then the so you didn't take it then?
Not yet.
Okay. Yeah. Introduction to corrections. I teach that one next T1 starting October
Is it a,
5th, and then I also will be teaching constitutional law. But I won't have any of you guys for that because that's a bachelor program course.
I'm in the bachelor program.
You're in the bachelor program?
Yeah.
Oh, okay. Well, if you're in the bachelor program, then you constitutional law, and you both of you guys are. Oh, okay. So then you came from other schools though before for the associates, right?
Yeah, I have my associates in paralegal studies.
Okay.
So then
Okay.
they made us take.
So then, Jonathan, are you going to be in any of either any of my class? You're going to be in the constitutional law class? You know? Uh-huh.
I don't
All
think
right.
I'll be next
Yeah.
semester.
I love teaching that class. That is a very interesting course. So all right, guys, I'm going to say good night to you. I
Wait, do we get our
wish you guys the best. And
do we get our phrase?
I thought I gave it to you.
No. You started
All
talking
right.
about it, and then we talked about questions.
All right. It's an insanity defense.
Insanity.
Insanity defense. Since that's what's been going on pretty much this whole session, I was ignoring, but I paid attention to it at the same time. I'm a very good multitasker. Trust me. I mean, and there are things that I observe and pay and don't say. My kids will tell you, they said, my dad must have eyes in the back of his head because he saw stuff behind his back that was going on. I said, that's okay how I know it. I'm not going to let you in that secret, but I do. So anyway,
It happens after a while to me. They just start ignoring me. No.
that's okay. That's okay. That's all right. All right, guys. So you stay safe, enjoy your break, and I'll see you down the road. And this is what I do also tell students that if you need to reach out to me for anything after the course, I have students that ask me for letters of recommendation and stuff like that. And so I help students um, to be successful in their careers. Remember, my thing is, as I said, week one, ethical, professional, and educated. I think that will fix some of these problems that are happening in law enforcement. So with that, I'm going to say good night to you guys. Now, I'll see you next quarter if I do, if not further down the road. Good night.
Yeah. Have a good one.
You too. All right. Bye bye.